Good afternoon. Hope everybody's well. I'm Janice Kaminer-Resnick, and I welcome you on behalf of the members of our leadership team, which aside from me is former Congressman Mel Levine and former Los Angeles County Supervisor Zev Yaroslavsky. Tonight, as you can see, I'm not in my usual location. I'm actually in a remote area of Nova Scotia, Canada, celebrating my 50th wedding anniversary. Of course, I'm with my husband, and I am grateful that Canada has such great internet connectivity. We welcome and thank tonight's special guest, UC Berkeley School of Law Dean and one of the country's most respected constitutional law scholars, Erwin Chemerinsky. Because of the Trump convictions last week, we asked Dean Chemerinsky if we could have an extra half hour of his time tonight to discuss the legal aspects and implications of the 34 Trump convictions, in addition to tonight's main topic, which is anti-Semitism on college campuses. This is part 2 of Dean Chemerinsky's visit with America at a Crossroads on this topic. Part 1 was in January of this year. With all that has transpired on campus and personally to Dean Chemerinsky since January's visit, there's a great deal to discuss. Thank you so much for being with us and agreeing to that extra time. And thank you as well, of course, and welcome to our esteemed moderator, Warren Olney. Next week on June 12th, Franklin Foer, staff writer at The Atlantic and former editor of The New Republic, will be discussing the content and analysis contained in his recent epic article in The Atlantic entitled "The Golden Age of American Jews is Ending" with Madeline Brand. In tonight's email that you get right after the program, you'll receive a copy of that article, which is the foundation of next week's program. I highly recommend that you read the article. I have provided it to you without a paywall, so you will all be able to access it. The following week, we have 2 programs, one on Monday, June 17th, which will be a special program with Ambassador Jim Jeffrey, now with the Wilson Center, and the Atlantic Council's Tom Warwick, who will discuss a joint proposal of the Atlantic Council and the Wilson Center about governing in post-war Gaza. You can register for the June 17th program, which is entitled "After the War, a Plausible Proposal for Life in Gaza." In the email you'll get after tonight's program, our moderator for that program will also be Warren Olney. And the second program that week is our usual Wednesday night, June 19th. It is a program with the very interesting Noah Feldman of Harvard Law School. He just published his 10th book, and this one happens to be called "To Be a Jew Today." On October 19th, he will focus on the topic, how October 7th has forced Jews to reckon with Israel. The book is very interesting. I'll send you a link to it if you consider reading it before the program. That program will be moderated by Madeline Brand. Now, to introduce our speaker and begin tonight's program, please welcome the wonderful Warren Olney. Warren was the host and executive producer of the nationally syndicated Public Radio International weekday afternoon program, To the Point. He has won many, many awards, too many to name right now, and many were conferred by his colleagues and peers, and they are a tough crowd. He can attest to that. We are very lucky that Warren has blessed America with America at a crossroads with his truly exceptional skills. Warren, tonight's special 90-minute program is now yours. Thank you.
Janice, thank you so much, and have a good time in Canada. That's a good place to be, especially for your 50th wedding anniversary, and congratulations on that. It is always my pleasure and privilege to talk with Erwin Chemerinsky. National Jurist magazine has called him the most influential person in legal education in the United States. He was founding dean of UC Irvine School of Law. He's now dean of the law school at UC Berkeley. 200 law review articles, many columns for the LA Times and other newspapers, 19 books, including Worse Than Nothing, The Dangerous Fallacy of Originalism, particularly appropriate today. Not just a dean, a professor, a scholar, he also argues appellate cases at the U.S. Supreme Court and elsewhere as well. And he's a familiar presence on this program, as Janice just indicated. Most recently, in January, he talked about anti-Semitism on college campuses, and he's here today for part 2 of that conversation. And Dean Chemerinsky, welcome. Great to have you.
It's so wonderful to talk with you again.
Now, before we get there, as Janice mentioned, this is actually a 2-segment production. We're going to go for an hour and a half. And we have to get your views on the event that has made such legal and political history. Just this past week, the first felony convictions of a former president, Donald Trump. And we'll talk about that, take some audience questions about that as well, and then we'll move on to anti-Semitism in campuses, which is our major theme for the day. So, Dean Chemerinsky, Was the conviction, are the convictions a victory for the rule of law?
I think very much they're a victory for the rule of law. The core of the rule of law is that no one, not a president or a former president, is above the law. A jury that was selected, and the way juries are always chosen, heard all of the evidence and concluded that Donald Trump was guilty as charged. That really does stand for the idea no one is above the law.
Has he, in the process, or was he in the process of the trial, treated differently than other candidates or other defendants might have been?
I think it's important to separate two questions. One is, should he have been prosecuted for these crimes? And then, if so, second, was he guilty of these crimes? And I think the question you just asked goes to the first of these. And I think it's important to recognize that business crimes like this, falsifying business documents, falsely entering information, crimes that do get prosecuted. Michael Cohen had already gone to prison for his role with regard to these crimes. And I think what made these crimes serious and the reason why the prosecution was justified is he committed these crimes in trying to increase his chances re-elected president of the United States. Whether falsifying documents so as to hide hush money paid to about a sexual affair generally should be prosecuted, it's a hard question. But when somebody's doing it and trying to change the outcome of a presidential election, it really does go to the core of democracy. And that's the point the prosecutor made in the closing argument.
Well, as a scholar, a legal scholar, what do you think about the fact that the charges, which have been called a legal concoction by some people, were a combination of state law on business documents, as you indicated, but also federal election law? Why is that appropriate, especially when the Federal Elections Commission didn't bring any charges at all?
Because the state of New York has a law, and it's a constitutional law, that says that if somebody is falsifying business documents to advance their campaign, that becomes a felony in New York. And I think it should be a felony in New York. Maybe the easiest way to answer your question is there were really three issues before the jury. One is, did Donald Trump pay or authorize the payment of $120,000 in hush money to Stormy Daniels? I don't think there's any question about that. Second, did he try to hide this as business expenses in various ledgers and check records? Again, the documentary evidence seems clear. And third, did he do this to help his chances of being elected president? And again, the evidence of that seems clear. In New York has laws that make that a crime, and it's certainly its prerogative to choose to make that a crime.
How worrisome are you, or worrisome to you, are the attacks on the judicial system and the claims that this is a demonstration that, in fact, it's politically rigged and that the president might even have had something to do with it, working and sending a Justice Department official to be a part of the prosecution and all of those things that have been claimed about it?
I'm tremendously worried about the attack on the judiciary. I worry about how it undermines the legitimacy of the court in many areas. So this wasn't a prosecution brought by the Biden administration. It was a prosecution brought by the district attorney of New York. And I think it's wrong to say that Biden was responsible for this. President Trump and his supporters have said he couldn't get a fair trial in New York City. This is frightening. Does this say that conservatives can't be tried in New York or liberals can't be tried in Alabama? That's never been an argument within the judicial system. I have no doubt that if the jury had acquitted Donald Trump, he would be taking that as exoneration and he wouldn't be attacking the judicial system. But it's only because he was convicted that he's saying that the judicial system is flawed.
Back to the question of treating some people differently than others, what about the potential sentence, especially after Mr. Trump, former president of the United States, violated so many gag orders? Is it, do you think, unlikely that he'll get a prison term, given that he's going to be a candidate for president? It would appear of the Republican Party. Does that justify perhaps letting him off the hook, as it were, when it comes to being a convict who goes to jail?
I don't know what sentence the judge is likely to impose. I don't have a prediction. I think it is a terribly difficult question for the judge.
Mm.
To be clear, each of the counts carries with it a possible sentence of 4 years in prison, and there'd be a maximum of 20 years in prison imposed. On the one hand, this is a so-called white-collar crime. He's not a danger to society in committing similar crimes in the future. He's a first-time offender, which is often taken into account. On the other hand, remember, Michael Cohen went to prison already for his participation in this crime. It was a situation of Donald Trump flouting the law. And one of the things that judges take into account is whether there's remorse shown. Donald Trump has certainly shown no remorse. I also think a factor is that the judge imposed gag orders and Donald Trump openly flouted them. And the judge was restrained in not imposing jail then. But that might also be a factor in the judge's sentencing now.
A factor, do you think, that would encourage him to, or make it more likely that he sends him to jail?
I think Donald Trump's disregard for the law, as evidenced by violating the gag orders, could influence the judge towards wanting to impose some prison time. But there's also, as I say, factors that point the other way. What's important for everyone to know is it is in the discretion of the judge, is it so often in the discretion of the judge in terms of the sentence. And something else we haven't mentioned, if Donald Trump is sentenced to prison, he cannot pardon himself if he's elected president of the United States. A president can pardon only as to federal crimes, not as to state law crimes. But there is potentially unprecedented issue. Imagine Trump is sentenced to prison, but then elected president. Does his election as president preempt the ability of New York to imprison him? We've never faced that question before in American history.
Some fascinating questions arising. Mr. Trump himself says he's ready to go to jail again in order to save the country, if that's what it takes. He knows how to respond to this stuff. What is your take on the media reporting of this case and of the situation with the judicial system in general? Has it, do you think, done the system proud? Has it been good, or do you have some concerns about it?
I think the difficulty for the media is they need to report both what's going on inside the courtroom and what's going on outside the courtroom. I think they did a good job of reporting what was happening during the trial. I wish there had been cameras so we could all watch for ourselves. We had to rely on people who watched telling us about it.
Yeah.
Cameras aren't allowed in courtrooms in New York. But I felt on a daily basis we were getting a good summary of the questions asked by the lawyers, the witnesses' testimony, the judge, and how the judge was handling the case. But then there was the circus going on outside the courtroom. There were leading politicians, the Speaker of the House of Representatives, a senator from Ohio, J.D. Vance, going and being Trump's spokesperson outside the courtroom. And then there's all of what's gone on outside the courtroom since the verdict came down with those criticizing the verdict. And I think the media has done a good job of reporting. I worry that sometimes it tries too hard to just present what's said without enough analysis of it. So some of what's been said by those who criticize the verdict is just flat out wrong. The argument that Donald Trump couldn't get a fair trial in New York has no legal basis. And I wish the media would point that out more.
You mentioned Mike Johnson, the Speaker of the House of Representatives. He has said that he thinks friends of his who are on the U.S. Supreme Court are eager to intervene in some way, although he wasn't specific about it and kind of tried to back away from it a bit, when he was questioned about it. But what does it say to you when the leader of one of the major branches of government says that about another branch of government under these kinds of circumstances?
I am very worried generally about a loss of trust in American government. I think the critics of this case and the verdict are contributing to that. As to the comments here, I can't believe that any justice on the Supreme Court intimated to the Speaker of the House their views on this case. Supreme Court justices don't do that. If they did it, it's inappropriate. And if they did it, it's inappropriate for the Speaker of the House to say it. So I took it as hyperbole, but inappropriate hyperbole. And let me also be clear. The United States Supreme Court can review this conviction or the sentence only if it turns out there's an issue of federal law.
Yeah.
New York gets to decide questions of New York state law. What Donald Trump would ultimately have to show, after going through all the New York appeals, is that his constitutional rights were violated. My sense, from having followed the trial pretty closely, is that's going to be very hard for Donald Trump to come up with a constitutional issue. Otherwise, the US Supreme Court can't hear the case at all.
Let me get some questions from our viewers. Susan wants to know, why is Trump allowed to get away with so many violations of the law and good taste? His behavior in the recent trial was a disgrace.
I think the judge in the trial exercised appropriate restraint. My guess is, had it been any other defendant, person would have been held in contempt for uttering expletives in the courtroom and behavior in the courtroom. I think probably as another defendant who violated a gag order, they would have faced some jail time from the judge. And I think what the judge was trying to do was go out of his way to seem fair. And I do think Donald Trump got benefits that other defendants wouldn't get.
Dave wants to go back to the U.S. Supreme Court. Do you think Justice Alito is thumbing his nose at the country, saying, ha, 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 you can't do anything to me. I'm here for life?
Yes, I think that Justice Alito is tone deaf with regard to ethics issues. The Supreme Court has its lowest approval ratings in history. I think part of that is because of the ethical controversy surrounding some of the justices. And that's a self-inflicted wound by the court. Until November of 2023, the Supreme Court had no ethics code for the justices. Every other judge in the country, state and federal, had to obey an ethics code, but not the Supreme Court. When they adopted an ethics code, it was a watered-down version of the one that applied to other judges, and it had no enforcement mechanism. It's left to each justice to decide for himself or herself whether to disqualify in a particular case. So what happened last year when Justice Alito was found to have impermissibly taken a fishing trip with somebody, rather than say, I was wrong, I shouldn't do this, his response was, well, nobody else was going to be in that seat on the airplane. That's not an excuse for an ethical violation. And then when it was pointed out that a flag that represented support for those who had engaged in the insurrection on January 6th was flying in front of his house, the appropriate response of any other judge would have been, that was wrong, it shouldn't have been there. Or instead he said it was my wife and she had First Amendment rights. Well, of course she has First Amendment rights, but then he should be recused from the case. But I think, as I said, that he's insensitive to how he's perceived. And I think he's insensitive to how much this tarnishes the Supreme Court. And one consequence of that is I think it tarnishes all courts, that most people don't distinguish among levels of court, federal or state. I was recently talking to a justice of state Supreme Court, another state, and he talked about how the approval ratings of his court had gone down, even though there had been no controversial rulings or nothing had been done by their court. And he said, as the Supreme Court's approval ratings go down, so do the approval ratings of state Supreme Courts. And I think that's right. And I think that does really have a serious consequence for our society.
Here's an anonymous questioner wants to know about these contempt of court convictions. Are they felonies? Are they misdemeanors or something else? And would they be considered prior convictions at a time of sentencing?
I don't know New York law. My impression would be that these would be much more likely civil contempt, but they wouldn't be considered to be prior convictions. But they could certainly be taken into account by the judge as part of what he looks at in sentencing. In the federal system, for example, a judge can even consider crimes for which someone was acquitted in deciding whether or not to have them play a role in sentencing. Somebody could be charged with 10 crimes in the federal court, acquitted on 9 and convicted on 1, and the 9 acquittals could still be considered in imposing the sentence on the one where there was a conviction. And that's because to convict somebody takes proof beyond a reasonable doubt, but a sentencing factor in federal court only takes preponderance of the evidence.
There has been a lot of talk about the jury instructions involved in this case, and Robert, who says he is an attorney, found those instructions very complicated and very difficult. He says he doubts that the jury really understood them. Does that open up grounds for appeal?
I think Robert raises an important point about jury instructions more generally. Often they are far too complicated. And there are professors who've done studies with regard to jury instructions and jury comprehension and have documented the problem. On the other hand, I don't think the complexity of the jury instructions would be a basis for a court overturning the convictions. Jury instructions are often far too complicated. And ultimately, it did, as I said, boil down to a few simple questions. Did Donald Trump cause business records to be changed? Did he do so for his own political benefit? And if the answer to those questions were yes, and the evidence seemed clear about them, then the jury verdicts are likely to stand.
Okay, Ruth has a lengthy question here. What are we going to do about the 11th Circuit today? I didn't know this. I hope that Ruth is correct. Saying they will not take any further complaints about Eileen Cannon, the judge, of course, in Florida, who's overseeing the charges having to do with with President Trump and the highly classified documents that he removed from the White House. He says, does that mean, does this decision by the court mean that Jack Smith can't bring charges against her, either writ or mandamus, or making her recuse, or at least an admonishment by the 11th Circuit, as they did in the special prosecutor initially picked by Cannon? I'm sorry, kind of hard to read that question, but I think you got the sense of it.
Sure. What's important to know is that when a case is pending in federal trial court, it is very difficult to get the Federal Court of Appeals involved. There's a strong presumption that a case should finish in the trial court before the Court of Appeals gets involved in the matter. And so it's very difficult to get a Court of Appeals to admonish a trial court judge while a matter is pending, to remove a trial court judge while a matter is pending. And I think what the 11th Circuit is basically saying here is Judge Cannon has been assigned the case. This is her case. She'll handle it. And then if the defendant loses, the defendant can appeal. But I'm not surprised that the 11th Circuit here is saying, we're not going to get involved in this stage. On the other hand, there's a number of rulings that Judge Cannon has made that not only skeptical about, but I think at times she's been wrong as to the law.
Barbara wants to know, should the jurors involved in this case be fearful of revenge or retribution from Trump or his followers? I think that's asked for kind of a speculative answer, but threats have been made, and it seems to me it's worth getting your comment on them.
I hope so much that never happens. I know they tried to protect the anonymity of the jurors. The jurors were performing their civic duty. The jurors took a good deal of time out of their lives and did what they were asked to, listen to the evidence and render a verdict. And it would truly be shameful, disgusting, if any actions were taken in reprisal against the jurors. But we all know the world we live in now, it's possible.
Susan wants to know, the executive branch and Congress have to answer for their actions by ethics rules, according to ethics rules, and they can even be impeached. How did the founding fathers leave the judicial branch so unaccountable? I would point out judges have in fact been impeached, federal judges.
Yes, I mean, they didn't leave the judiciary unaccountable in the sense, as you point out, a federal judge can be impeached and removed. I think there's about 15 federal judges in the course of American history have been impeached and removed from office. And there are ways in which Congress can exercise control over the court. Congress sets the budget of the Supreme Court. Congress sets the salary of Supreme Court justices. Congress sets the number of Supreme Court justices. Congress can create and has created ethical rules for Supreme Court justices. And so there are some statutes there. I think that it's been a mistake that there hasn't been an ethics code for Supreme Court justices until they created one for themselves in November of 2023. I'm one who believes Congress could constitutionally create a set of ethics for the Supreme Court, just as Congress creates ethical standards for the president and the executive branch of government.
It's been argued too that there are other ways to go about that. Jamie Raskin has a long and complicated proposal, which I don't understand. Perhaps I'm sure you do. Tell us a bit about that.
Sure. Jamie Raskin is a congressman from Maryland, did an op-ed in the New York Times last week. And he basically said that the Solicitor General of the United States the lawyer in the Justice Department representing the states in the Supreme Court, could make a motion to the other 7 justices to recuse Justices Thomas and Alito. And he says the other 7 justices should then rule on the motion and disqualify their colleagues. There's nothing that would require the other justices to rule on this. And if I had a prediction, knowing something about them, I don't think the other 7 justices would want to touch disqualifying colleagues.
What about the Chief Justice?
There's no precedent for the Chief Justice formally recusing a justice. On the other hand, we know of instances where the Chief Justice has gone to a justice and said either be recused or, for example, when Earl Warren was Chief Justice, we have reason to believe he went to Abe Fortas and said that because of Fortas's ethical lapses, Fortas should retire from the Supreme Court, and Fortas did. But there's no formal mechanism that exists. There's no rule that says that the Chief Justice can disqualify a justice.
And we don't know for sure that Earl Warren did, in fact, exert that pressure on Abe Fortas.
We don't know for sure, but it's a story that's been told many times.
We've talked a bit about Trump and whether he would have been charged if he was not running for president. Eric wants to know, do you think that Hunter Biden would have been tried if he was not the president's son? Of course, that case was brought by the Justice Department when Trump was, in fact, the president.
It's so hard to answer. I mean, this is the crime of having a firearm while in possession of illegal drugs. We should know that this is the kind of crime that does get prosecuted, even for those who aren't president's son. Drug crimes, gun crimes have been, I think, much over prosecuted in this country. So we can't say that Hunter Biden is being singled out. Would it have come to the attention of prosecutors? Would they have brought the case if he wasn't Joe Biden's son? I don't know any way to answer that question.
Now, here's a question from Carol. Are convicted felons prohibited from association with other known felons?
The answer to that is generally no, there is no such prohibition. That generally there isn't a law that says if you're a felon, you can't talk to or associate with another felon. Again, there's particular instances where that might be. There are, for instance, gang injunctions that keep those who are identified as gang members from associating with other gang members, but it's always going to have to be some specific law like that. There's not a general prohibition.
Okay, well, I think that we've spent as much time as we need on that subject, and I think people are eager to hear more from you about anti-Semitism on college campuses, something that involves you very personally and has for a long period of time. So as advertised, we're going to return to the issue of anti-Semitism on campus. Since October 7th of last year, and since part 1 on this topic in January, there have been multiple demonstrations and disputes about Israel's war in Gaza. It happened at Harvard and Columbia and UC Irvine and USC and UCLA, among many others. And in April, at a dinner that you gave at your private home in Oakland, you were celebrating this year's graduates of the UC Berkeley Law School, where you are dean and your wife, Catherine Fisk, is also a professor. Now, it's been widely reported, it's been all over the news media, that at this dinner, which occurred on a Tuesday night, you and she were involved in a confrontation with a Palestinian student who is also a member of Students for Justice in Palestine. Tell us, if you will, what happened.
Sure. As you know, I've been involved in controversial issues. I've often discussed them on your program. I've written a lot of controversial things. I never could have imagined that the most controversial thing that I'd be involved in would be a dinner in my backyard for graduating students. I do think it's important to put this in context. My wife and I hosted dinner for entering law students at the start of the school year. We usually do this over many nights so that all the students can come. The class that graduated in 2024 didn't have dinners when they started the law school because of COVID, and the presidents of the third-year class asked us if we would host dinners for them, and we did so. There to be April 9th, 10th, and 11th. The week before the dinners, a poster went up on every bulletin board in the law school, and it also went online. It had a caricature of me holding a bloody knife and fork and with what appeared to be blood around my lips, and it called for a boycott of, quote, Zionist Chem. I assume they used Chem because Chemerinsky didn't fit on the poster, and Zionist is that I was Jewish. The posters didn't object to anything that I had said or done. I have not taken public positions about what's going on in Israel. The law school doesn't have a foreign policy. The only demand on the poster was that the University of California divest from Israel. Of course, that's not in the control of the law school and largely isn't in control of the campus. It's up to the regents of the University of California. A number of students and staff objected to the poster, saying it made them feel unsafe in the building. But my position was it was speech protected by the First Amendment, though I found it hateful. It invoked the awful anti-Semitic trope of blood libel. Why else have blood on the knife and fork and blood around my lips? On the night of April 9th, we welcomed the students. My wife and I always greet them in front of our house, and then they go to the backyard where there's refreshments and then dinner. I was surprised to see the students from the Justice in Palestine group come to the dinner because they'd urged a boycott. I initially had a thought of, I hope they're not going to cause any trouble, but then I thought it was wonderful that despite the boycott, they would come and join us. I was obviously being naive. After everyone had had a chance for refreshments, and after everyone had gotten their dinner, there's a buffet, and they're sitting down, the leader of the Students in Justice in Palestine, who had been responsible for the poster, took a microphone and an amplifier out of her backpack, went up on the steps, and began a talk about the plight of the Palestinians. I immediately got up and said, please stop, please leave, you're in our home, this isn't okay. My wife did that. My wife grabbed for the microphone. One of the students videoed it. It went viral very quickly, and then it became national news. The whole thing was enormously upsetting. I mean, I found the anti-Semitic poster just like a punch in the stomach. I think anybody who's ever been subjected to something that's racist or sexist or homophobic or anti-Semitic knows what it feels like when you're confronted with that. And I found that the student disrupting the dinner at the home, very upsetting. And then, of course, how it went viral was unlike anything I've ever experienced.
You are a powerful advocate of the First Amendment, and as you indicated yourself, that you didn't want the posters taken down or have any problem with it, but you make a distinction between what happens elsewhere and what happens in your private home.
Well, to start with, that even if this had been in the law school, there'd be no First Amendment right to disrupt the event. Last night, I hosted an event for federal judges from around the country within the law school. If a student had come and done that in the law school building, it still wouldn't have been okay. There's no First Amendment right to disrupt events in that. But you don't get more First Amendment rights by coming into my home. This is my private property. And in fact, under California law, once I said to the student, please leave, she was legally a trespasser. There's no First Amendment right to disrupt an event at my house.
Did you call the police?
No.
Why not?
The students left. I doubt I would have called the police in any event. I certainly had no desire to escalate it. Now, I've got to say, it all happened very quickly. We're talking about something that happens within 5 minutes and how you react. After my wife grabbed the microphone, the student said, if you let go of the microphone, we'll leave. My wife let go of the microphone. This student, about 9 others, took off their jackets to show matching pro-Palestinian t-shirts, left flyers all over the backyard, pro-Palestinian, and they left. And that was the end of the event, but certainly only the beginning of the media attention.
So they were obviously prepared in various ways and even were able to take a video of what took place. And interesting, your description of how they took off their shirts and had t-shirts underneath. Were they, do you think, looking for a public confrontation? Did they want to see this go nationwide and worldwide, which it did?
Absolutely. I think that we were set up and we fell into it. We brought someone there in case there was a disruption so that Catherine and I wouldn't be the ones dealing with it. But that person was in front of the house thinking if there was a disruption, it would be protesters out on the sidewalk and street.
Yeah.
But I think the students absolutely wanted what they got and ended up getting much more than what they hoped for.
So what should happen to those students? They're graduates. I don't know if you can withhold their degrees. Is that something that ought to be done? Should they be disciplined? And what has in fact happened? It's been a few weeks.
Sure. Any university disciplinary proceedings concerning a student are confidential. So if there were student disciplinary proceedings against them, I wouldn't be able to discuss that. I personally favor restraint with regard to student disciplinary proceedings. But I think there's an important question of when a student violates the rules in that way, and it's clearly violating school rules. School rules prevent disrupting school activities. School rules are clear that when there's lawful instructions given by a administrator or faculty member, the students are supposed to follow it. And then I think there's the really interesting question of when should there be student discipline under those circumstances?
Back to the question of the hour. Do you think that this action was anti-Semitic, or was it in fact part of the ongoing protest against the killing of so many people by the Israelis in the aftermath of the horror that happened on October 7th?
To be clear, I don't believe criticizing Israel's policies, anti-Semitism, any more than I believe criticizing policies of the United States are anti-American. So I don't believe that protesting what Israel is doing is inherently anti-Semitic. But that said, as part of them, anti-Semitism can be expressed. So I think the poster that was put up of me calling me Zionist Chem with a caricature with a bloody knife and fork and blood around my lips was anti-Semitic. Can you divorce what went on in my backyard from that poster? That to me is a much harder question since it was done by the same students.
There's an interesting dialogue that was reported in one of the newspapers, quoting your wife, Catherine Fisk, as saying, "We really agree with you about what's going on in Palestine." This apparently is also on a videotape. She said that as the students were leaving, and one of them said, "Well, what have you done then about divestment?" Nothing, nothing. Then your wife responds, "We don't control the investment." I'm interested in that whole question of divestment. And you mentioned earlier that campuses probably don't have a control over that, but only the Board of Regents does. Is this something that the board ought to be considering?
I do want to clarify, the law school plays no role whatsoever in how the investments are handled.
Yeah.
The campus trustees have some control over campus investments, but ultimately the Regents of the University of California set policy. And the Regents of the University of California thus far have opposed the boycott, divest movement and have refused to divest. I'm skeptical that divesting in Israel is something that would be more than symbolic. And no reason to believe that the investments of the University of California have any role with regard to policy in Israel. As I say, thankfully, the issue of divestment is not something that the law school has any involvement in, but I'm skeptical of it being more than something symbolic. The University of California just doesn't have significant enough investments, nor do colleges. And often, as I understand it, the way investments are handled is they're part of large funds that can't be segregated in terms of which part is the University of California's investment in Israel.
What about the use by Israel of weapons that are sent there by the United States? Does that change the argument somewhat, particularly when it was revealed just the other day that a particular bomb that did in fact kill civilians was identified? I don't know how they did this, but I believe it was the New York Times or maybe the Washington Post, that said they had identified it as an American weapon.
Maybe the best way I can answer is to say, putting it in context, I don't think we can talk about Israel is doing outside of talking about what Hamas did on October 7th, which was horrific. I believe that Israel had to respond to what Hamas did, but I'm very critical of the way in which Israel has approached this in Gaza and the tremendous loss of civilian life. Whether they're using American weapons or not, to me, isn't the key. The key is this a strategy that's likely to be successful in protecting the security of Israel? And is Israel doing all that it can to protect civilians? I'm not an expert with regard to this, but from what I've read, I'm very concerned about those questions.
A lot of people have died, civilians and many children, and we have seen this. And now it's very difficult to get life-saving food, not to mention water, into the people that are still suffering from the attacks by the IDF.
And I want to be clear, I think criticizing Israel for how it's waging the war in Gaza is not anti-Semitic any more, as I said, than criticizing a United States policy is anti-American. But we've got to be clear that as part of the protests, anti-Semitic things have been said. I saw pictures from George Washington University where somebody held up a poster saying final solution. Or I saw a number of different videos where those in encampments were calling out to those who appeared to be Jewish, go back to Poland. Those things are anti-Semitic. And so we should condemn the anti-Semitism. We just shouldn't say that just because there's anti-Semitism, the criticism of Israel for what it's doing in Gaza is inherently anti-Semitic.
Long prior to all of this, in October of last year, just a couple of weeks after the attacks of October 7th, you wrote a piece in the Los Angeles Times where you said that you thought that administrators ought to be speaking out if there are incidents that appear to be anti-Semitic on campuses. One, do you think the incident at your house was in fact anti-Semitic? And two, we talked about discipline a bit earlier. You don't know about that, but secondly, if it was, or if it was, what have the administrators at UC Berkeley had to do about it? As you indicated, there's a lot of levels of organization at that institution. But you did something that muffled you. You're not, I can't hear you now. No, I don't think, or did I do it? No, I don't think so.
I don't know.
There you are. Now you came back.
Oh, good. I'm so sorry.
There you are. You had something.
I don't know. And hopefully this will work now.
Yeah, you're fine.
I'm so sorry. Yes, I believe that what happened in my house was anti-Semitic. Let me try to explain why. Some of it is the poster that preceded it, but some of it is I believe that it wouldn't have happened if I weren't Jewish. Because it wasn't about positions that I've taken. It wasn't about anything I had said or done. The only reason to target my house was because I'm a Jewish dean. I don't believe it would have happened if I wasn't Jewish. John Perez, who's a regent of the University of California, did an interview in Politico, which was around April 13th, where he explained why he believed that what had happened is anti-Semitic. And it fits with what I was saying generally. I think we have seen since October 7th much more expression of anti-Semitism on campuses across the country.
You have been very critical of the Netanyahu regime from time to time, not just since the attacks.
Yes, I believe it's possible to strongly support the existence of Israel and also strongly support Palestinian rights. I've litigated cases on behalf of Palestinian rights. I've always favored the idea of a two-state solution. But this again fits with what I've been saying to you. I don't believe that criticism of Israel's policies or Netanyahu are anti-Semitic. Think of all of the Israelis who took to the streets to protest Netanyahu's policies.
I think, Arnold, let me go to the viewer questions and mix them in with my own. I think a lot of people want to get involved. Arnold wants to know, how has the faculty at UC Berkeley reacted to this incident and UC Berkeley Law School, I should say, and all the fallout that's incurred since?
The faculty has been wonderful. Something that could have potentially divided our faculty didn't divide our faculty. And there have been a number of instances where the faculty has gone out of their way to express support for Catherine and me.
Let me ask you this about things that have happened in other institutions. If I can find the note I had on that. There have been a number of places I can't. Oh, here it is. San Jose State suspended a professor over pro-Palestinian work of some kind. Sonoma State, a president retired there after being placed on leave for supporting the anti-Israel boycott. And of course, there was an incident at UC Berkeley as well. Pro-Palestinian group took over a UC Berkeley building. I'd like you to comment on all of those things. I don't know if you know them in detail,
Sure.
but there's a lot of action occurring. Does it sound appropriate to you to take action against people for their pro-Palestinian work on campuses?
I think it depends on how and when they express the pro-Palestinian views. People have the right to express pro-Palestinian views or pro-Israel views or any other views on campus. I think the core of what academic freedom and freedom of speech are about is that all ideas and views can be expressed on campus. But no professor should be going into class and proselytizing a view on this or any other issue. So there was an incident, unfortunately, at Berkeley where an instructor said, "I'll release you from class if you'll go to the pro-Palestinian rally." That's inappropriate for the professor to do. Or if a professor says, "I'll give you extra credit if you'll go to the pro-Palestinian rally or the pro-Israeli rally," that's inappropriate to do. There's an incident at Stanford where a professor, to try to make something dramatic, had the Jewish students have to go back in the room and treat them as inferior. And that instructor got disciplined. That's completely appropriate. So yes, on campus, all ideas and views can be expressed, but there's limits in the classroom to what's appropriate. And certainly for a university administrator, there's limits on what's appropriate to say. Universities often have policies in terms of what can be expressed on behalf of the university. I think it's very important in answering your question to separate what's a violation of the law versus what's a violation of campus rules. Taking over a building, engaging in vandalism, putting graffiti on the walls, that's a crime. And that's very different than things that are violating campus rules in terms of where encampments are put and the like. The campus constitutionally can punish those who violate the campus rules. The question that's hard for administrators is when to do that.
At UC Berkeley, there was a kind of resolution to the issue, was there not, where the building was taken over by the pro-Palestinian students?
Well, I want to separate the resolution of the encampment from the resolution of taking over the building. The encampment was resolved, I think, in large part because commencement happened and the students were going home, but also with the chancellor, Carol Chris, saying that she would talk with the students and pursue possibility of the trustees of Berkeley engaging in divestment. But then there was a takeover of a building, and that, as I understand it, has led to criminal prosecutions. And it really goes to the difference I was drawing between what's a criminal act versus what's a violation of campus rules.
This gets very complicated. And speaking of rules, there don't seem to be any rule. Well, you're trying to formulate rules, I guess, that would apply anywhere. That would apply in Humboldt County, or they would apply in Maine or New York.
Well, and the starting point is for a public university where the First Amendment applies, all ideas and views can be expressed.
Yeah.
But also there can always be time, place, and manner restrictions with regard to speech. So long as they're not discriminating based on speech, based on the views expressed, and so long as they leave adequate places for communication. And with regard to the encampments at Berkeley or UCLA or Irvine or Columbia or Harvard, those encampments violated constitutional campus rules. The campus had the legal authority to clear the encampments. They had the legal authority to punish those who violated the rules with the encampments. I think the hard question isn't there a First Amendment or a legal question. I think it's much more a question of what's pragmatic and politically desirable. And I don't think there's been enough focus on that of what are the criteria we should think about of when to allow encampments and when to clear encampments, when to punish students and when not to punish students.
Do you have ideas about that? Do you have, you want to write a rule book?
I do. I don't know if a rule book is the right thing. I think that's too formal. But I've always looked at speech issues through the lens of the First Amendment. That's what I've been teaching all these years. That's what I've been writing about. And I think with regard to the encampments on the campuses, it's not a First Amendment issue. And so we need to think about from the perspective of what's pragmatic and politically desirable. What are the criteria? And let me suggest some things. One question always to think about is how much is the encampment or the disruption interfering with the educational mission of the school? If the encampment is in a corner of the campus and not interfering with the educational mission, it's very different than if it's a place where it's interfering with the educational mission or, say, preventing commencement from happening. Another criterion that I think is important is what's the risk of violence from the encampment or the protest? Campuses have the duty to protect the safety of students, staff, faculty. Of course, as the UCLA incident shows, often you don't know it's going to turn violent until it's too late. A third is how much is the harassment of students as a result of the encampment of the protest? One of the things that's very discouraging is often when there've been encampments, students were harassed, kept from getting through particular parts of campus, and that's unacceptable. A fourth criterion is what has been the past policy and what are the implications of allowing the encampment here? Because if the campus is going to allow blocking of a gate or an encampment for a particular group, it's got to allow it for other groups with different message in the future. A fifth criterion is what are likely consequences of trying to clear the encampment? How can it be done? Does it require police? And what are the implications of that for the campus? Should it be student discipline? And what are the implications of that for the campus? So what I've tried to do for you is say, these seem to me the kind of criteria that university administrators need to be thinking about. Unfortunately, we haven't been thinking in those terms.
Haven't up until now. Are you encouraged in any way? Have you seen any positive movement in this direction? Because what you're saying sounds to me like I think it's very profound.
I think so. I mean, we're still in the middle at this moment. For schools that are on the semester system, they've thankfully finished the semester and gone through commencement. But for schools that are on the quarter system, they're still in it and they still have commencement to go in the next 2 to 3 weeks. And we'll see if there's the same kind of disruptions of commencements. And then when this is done over the summer, as we look to the fall, we need to be focusing on the kind of questions that I mentioned. But one thing that I would say, and it really is about all we've been talking about, is that what's going on campuses now is different from what we've seen before. I was in college during the Vietnam War and participated in the anti-war protests.
Yeah.
The students were all on one side, or at least largely on one side. Now the students are deeply divided. They're divided in a way that at the moment, there doesn't seem to be a bridge between them. My pro-Palestinian students have very much taken the position that Israel should not exist at all. It should be an entirely Palestinian state. On the other hand, students, Jewish faculty, I'm one of them, who believe that the existence of Israel as a Jewish state is important. And this is tied to the identity of students, often in a very integral way. We have students who've lost loved ones in Gaza and students who have loved ones in Israel. This is tied to students' identity in being pro-Palestinian or being Jewish. And all of it's playing out in social media in a way that didn't exist, say, in 1968 when there were campus protests. So I think for campus administrators, we've never seen anything quite like this.
Do you believe that the Palestinians also are entitled to have a state of their own?
Yes. I've always believed in a two-state solution. I've always believed that the only way that Israel can be both a democracy and a Jewish state is for there to be a Palestinian state. And so I strongly support the existence of Israel, but I also believe in Palestinian rights and believe there should be a Palestinian state. And I've said that for years. So this isn't something that just new or as a result of what's gone on in recent weeks.
Well, should all organized religions and ethnic groups have their own nations?
Now you're beyond my expertise. I'm a constitutional law professor, but I do believe, given the history of the Jewish people, that Israel is important. I'm often struck in talking to my students how little they know of the history of the Middle East. I remember in November saying to some students, do you know that this is the anniversary of the Balfour Declaration? And none of the students I was talking to had ever heard of the Balfour Declaration. Of course, that was when England in 1917 said that there should be a Jewish state where Israel is. We can't ignore that Israel came out of the Holocaust and why it was so important after the pogroms, that there'd be a Jewish state. Israel has existed since 1948. I don't think the discussion any longer should be, should Israel exist? I think the question is, how can we have Israel, but also protect the right of Palestinians? And Israel has to have security, but we also need to protect the rights of Palestinians.
Back to the campus issue, Manny, there have been a few universities that have been more successful in managing these issues on their campuses than others. Do you have an opinion about which ones have been most responsible in minimizing anti-Semitism on campus since October 7th?
I haven't looked enough at enough campuses to say, these are the ones that have done it well, these are the ones that have done it poorly. I think it's crucial, as I said in the op-ed in the LA Times back in October, that when there is anti-Semitism on campus, campus officials speak out loudly against it. I think when there's anti-Muslim or anti-Palestinian sentiment, campus officials should speak out against that. I worry, though, that campus officials sometimes have been unwilling to criticize anti-Semitism for fear that it will seem Islamophobic. And I so disagree with that. Criticizing anti-Semitism is not anti-Islamophobic any more than criticizing anti-Muslim sentiment should be perceived as anti-Semitic. And I don't think campus officials generally have done enough to express that campuses have to be places where all ideas and views can be expressed. But anti-Semitism, anti-Muslim sentiment is unacceptable.
Sally wants to go back to the beginning and ask about those posters that you talked about that were put up with you with a bloody knife and fork in your hand. If you believe they were anti-Semitic and somebody posted such a hateful thing against other minorities, would you have asked that the poster be removed?
There is a First Amendment right to put the poster up, even if it's anti-Semitic, even if it's racist. If the poster had been about anybody other than me, I would have sent a message to the community condemning it. A number of years ago, when Harvard professor Alan Dershowitz was speaking at the law school, someone drew a swastika over his face in the poster. I immediately sent a message to the entire community condemning that and saying it's inconsistent with our most basic principles. On the other hand, in this instance, since the poster was about me, I didn't feel comfortable sending a message condemning what was a criticism of me. One thing that I would say, and it goes to the question, I think that if a poster had been put up on law school bulletin boards, there was a caricature of a black dean and used racist tropes, I think it would have been widely condemned in the way that this particular poster, though anti-Semitic, didn't get widely condemned. It certainly, I had Jewish staff and students object to it, but I do think there's a difference in how we perceive anti-Semitism compared to, say, racism, and I think that's wrong. I think they should be treated the same.
How do you think that came about? Why do you think that's the case?
I think that's a complicated question, and I'm not sure I know the answer. I think that Jews are now perceived as white, and as a result of that, anti-Semitism isn't treated the same as racism. And I'm in no way lessening my condemnation of racism, but I also think that we can condemn racism and condemn anti-Semitism, condemn Islamophobia without in any way lessening our sense that all of these are just wrong.
Laurice wants to know, what should college administrators and professors do to prepare for the fall semester to allow for open and civil discussions? And I would add to that question that it would appear that the situation in Gaza may well be going on as the fall semester approaches.
I've had 3 meetings in the last 2 days on that question. I'm petrified as to the fall because I think that the war in Gaza may be going on. Certainly the issue with regard to the Middle East will continue, and will superimpose on this an election that's going to be very divisive. My answer, at least from my law school, is it's going to take many things. One is clear messaging, messaging in terms of our policy, in terms of ideas and views can be expressed, our policy that there can't be disruption, our condemnation of expression of anti-Semitism or Islamophobia. And also, I always want to say to students, just because you have the right to say something doesn't mean you should say it. And that I hope that our students will choose to talk with respect to one another and treat one another with kindness. But I think schools have to have a message as to their policies. Second, I think there has to be personal contact. I want to meet with all the student groups, including the Students for Justice in Palestine, and make clear what our policy is and do so on a one-on-one basis. And I think we need to have programs. It's easier for me to think about what programs to do in advance of the election. And so we've been talking about that. It's harder for me right now still to think about what are the programs we do with regard to the Middle East. I can see continuing to bring in speakers who take the more pro-Palestinian position, and we have groups that will do that in the law school. I can see bringing in speakers who will take the pro-Israel position, and we have groups in the law school that would do that. My usual approach as a dean would want to put together panels where you have all views expressed. I'm not sure we're ready for that yet.
Whoa, why do you say that? You can't sit at the same table and have the conversation?
At least this spring, I don't think the groups have been willing to do that. And I don't know that we're at a point yet where there can be constructive conversation. Because I said, my pro-Palestinian students take the position Israel should not exist. When they say, we don't want no two-state, we want 48, they mean go back to 1948 before Israel.
Yeah.
And on the other hand, my Jewish students who believe, and others besides the Jewish students, that Israel should exist, I don't know yet whether we're at a position where we can have those positions expressed in the same form and it be constructive. I hope we'll get to that position. We were there before October 7th. We had a number of programs where both the Palestinian and the Israeli positions were voiced. But I want to make sure that whatever programs we have are constructive and enlightening and that they generate more light than heat.
You've probably noticed, or you might have noticed, that we have arrived at the hour of 6 o'clock. Let me just remind you that we are, in fact, going to continue on until 6:30. Dean Chemerinsky has been kind enough to be available for that length of time. So I just wanted to make that point. And as they say on television, don't go away. We got more. So here is Manny. Do you think that students who are protesting understand that the foundation of Hamas is the death of the Jews? It's in their charter. It seems that the student protesters are supporting Hamas more than the idea of a two-state solution. Do they understand that the Jews have a thousands of years connection to the land, and that most Israelis were expelled from Arab lands? A lot of history in that, obviously, but it's pretty important history to understand.
I think it's hard to generalize about students because we're talking about a large group of people. And my sense is that some understand that about Hamas and support that. One of the things that I found horrifying after October 7th was student groups, including at Berkeley, issuing statements celebrating what Hamas had done in Israel. And so when they're celebrating what Hamas had done, that seems to reflect that, yes, they know what Hamas is and they're appreciating. On the other hand, I think there are a lot of students who have taken the pro-Palestinian side without understanding what Hamas is doing or without even wanting to support Hamas. They're just opposing what Israel is doing in Gaza. So that's what I mean, to be careful about generalizing. In terms of the history, again, I think some students understand, some don't. I mean, there's a rhetoric very much on the left right now that Israel was a settler colonial state and therefore was illegitimate. Well, the problem with that is, so is the United States a settler colonial country. Does that make the United States illegitimate? And when you deal with a place in the world where there have been Jews for thousands of years and what we would have called Arabs are now Palestinians for thousands of years, I don't know how you ever decide who is the rightful owner of what land. And so I think that for some students, the rhetoric about Israel being settler colonialist replaces an understanding and a knowledge of history.
What about that issue of understanding Hamas? Does that fall into the category of just people who simply aren't well informed about everything?
Again, I think it varies among the students. Let me give you an example. The Students for Justice in Palestine put up what they called a toolkit. And the last I looked, it was still online. And the Students for Justice in Palestine toolkit, which anybody can find, says that its goal is the destruction of Israel and that killing of civilians is permissible as part of a war of liberation. I know that some of my students have read that. And so for those students, you say, yes, they accept what Hamas is trying to do. But it would be a mistake to say that all of the students who are part of the pro-Palestinian movement, or all of the students who are protesting what Israel does, understand what Hamas is about and want to support Hamas.
Maura has an interesting question. What do you think about academic associations such as the American Studies Association taking positions on Israel and Palestine or other topics that don't have anything to do with their academic disciplines?
I personally would disfavor that. I mean, I talk about, let me start with, is it dean of a law school? When do I take positions? And then I'll talk about academic associations. My view as the dean of a law school is that I'm restrained in issuing statements, and I'll only issue statements if they relate to the law school. And I think my basic criterion is I will speak when my silence is the wrong message. So I felt after the death of George Floyd, to be silent was the wrong message. I thought after the insurrection on January 6th, as a law school, to not speak of the rule of law was the wrong message. But the law school, as I said to you, doesn't have a foreign policy. I haven't taken positions with regard to Russia's invasion of Ukraine, though I decry it. I haven't taken, as a law school dean, positions with regard to other conflicts in the world, because, as I think I've said this phrase before in this conversation, the law school doesn't have a foreign policy. Well, I think the same thing is true of academic associations. I was the president of the Association of American Law Schools in 2022. And there's always calls for associations like that to take positions. And my view was that we should only take a position if it relates to legal education directly. Otherwise, it's not within our purview. We didn't issue a statement when Roe versus Wade was overruled, even though I was very upset about it, and our executive committee was, because it didn't directly relate to the function of the Association of American Law Schools.
Has the association taken more statements since you ceased to be the head of it?
No.
Nikki wants to know, based on what you said about history, what can colleges do to educate their students as to the history of the Middle East and the formation of Israel? Do you think colleges have a duty and an obligation to do that? And if you do, if you feel that way, how do they do it?
Yes, I think that colleges do have that obligation. I think colleges have the obligation to educate about anti-Semitism and Islamophobia and racism. But I think with regard to the specific question, colleges and universities do have the obligation to educate students with regard to the Middle East. In answer to the question of how, there's many ways. There's courses in the curriculum. There are many courses in the curriculum at Berkeley, things like the history department, the political science department, when there's international affairs departments in schools that teach about what's gone on in the Middle East and do so from a historical as well as a contemporary perspective. But also one ways in which schools educate students is by speakers. We've had many speakers at the law school, but on the Berkeley campus, taking a whole range of positions about what's going on in Israel and the Middle East and presenting history. And students go to hear those speakers. So it's our obligation, I think, and it's not just at the college and university level. I'm often stunned in teaching college as well as law students at the lack of knowledge that sometimes they have of history. And so I think we all have a responsibility with regard to education.
Our subject, of course, is anti-Semitism on college campuses, but I can't help reminding you or reminding our audience, and I'm reminded myself, of what's happening now in many Republican states where there's an effort to control public school conversations in such a way that controversial issues, and particularly issues having to do with race and perhaps even anti-Semitism itself, ought not to be discussed, that they make people feel uncomfortable, that they're somehow it's wrong to do that. I'm just wondered if you're concerned about that kind of a development at those very important lower level public schools.
Very much so, and I agree with you. I think it's now about 18 states that have adopted legislation that prohibits the teaching of critical race theory. And part of it is saying that students shouldn't be taught in a way that makes them feel uncomfortable with regard to their race. Well, part of education is to challenge people's ideas and to make them uncomfortable. Also, I worry that a law like that is inherently unconstitutionally vague. How do you define what makes somebody feel uncomfortable? But there's something about laws like that that's so inconsistent with basic notions of academic freedom, what universities should be about. And there's legislation pending in some states challenging that. Arizona was one of the first states to adopt the law. It prohibited the teaching of ethnic study classes, and is specifically directed at stopping Mexican American history classes in the Tucson schools. And I argued that case in the United States Court of Appeals for the Ninth Circuit and won with the Federal Court of Appeals saying it violated the First Amendment.
Very interesting. Shumel wants to know, are you disappointed in your fellow faculty members that did not make public statements condemning the anti-Semitic posters that had your images on them?
No, I'm not disappointed in my fellow faculty members. I think that most of them paid no attention to it. That it was on all of the bulletin boards, but I think people often walk past the bulletin boards. I think for those who saw it, for many of them, it didn't register with them why it was so objectionable. And I think it's the nature of people try to avoid confrontation. On the other hand, there were faculty members, I should say, who were upset and did come to me. One faculty member said, I want to take them down from all of the bulletin boards. And I had to say to that professor, but under the First Amendment, they have the right to post them there. And again, I didn't want to be seen as censoring speech that was critical of me.
There's going to be a lot of events occurring, as I just indicated earlier, and we talked about earlier. One of them is there's going to be the visit of the Prime Minister of Israel, Benjamin Netanyahu, to the Congress, and that's coming up very soon. It's sort of off the point, I guess, but I assume that that's something that will be very much attended to by people on college campuses and at law schools. Are you concerned about that event and other events of that sort that draw a lot of attention to these issues, and are they liable to be sort of explosive?
If it occurs during the summer, it's unlikely you'll have significant protests on campuses for the simple reason the students have gone home. On the other hand, if it goes on in the fall when the students are back, yes, I think it could be a trigger of protests on campus. And there's nothing wrong with students protesting against Netanyahu. The question is, how do they do it? There are ways that are wrong for doing it. If they do things that are disruptive of the campus, if it is engaging in vandalism, if it's defacing property, then that's not protected. But there's nothing wrong with protesting Benjamin Netanyahu. Hundreds of thousands of people in Israel took to the streets to do so.
Yeah, and on an ongoing basis. We talked earlier about professors teaching that Israel is a colonialist power and who appear to be anti-Israel themselves. Ranana wants to know, what can you do about those people, those professors?
So much depends on how they do it. Professors certainly have academic freedom to teach as they wish, but academic freedom isn't unlimited. If I were to teach and sign somebody to teach contract law, and they wanted to protest and say, I'm never going to teach contract law, I'm just going to talk about the baseball pennant race, I could discipline that person. Academic freedom doesn't protect the right to do that. If there was a history professor and that history professor was going to teach that the Holocaust never happened, that's not a reputable theory. That person could be punished just like a geography professor who taught that it's a flat earth. No professor, no matter how much he or she tries, can be completely neutral in teaching. I try very hard in the classroom to make sure both sides come out, but undoubtedly in the material that I choose, the way I phrase things, my value judgments emerge. I don't want to try to indoctrinate anybody, but no one can be completely neutral. The question is, when does it shift from the permissible to the proselytizing that's impermissible? And that's a line that is so difficult to draw. And I've never seen anything that does a good job in telling us where is that line and when is it crossed.
Here's Renee, who has this question. We hear about outside influence and resources embedded in campus protests. To what extent do you think campuses are being influenced by anti-Israel, anti-Jewish, and anti-democratic influencers? There was a recent report about the billions of dollars donated by various Muslim countries to American universities over the last decade or so. I don't know that she's saying that those donations were necessarily designed to detract from Israel, but I get the point of the question.
Sure. I don't know about those donations. I've certainly never seen at Berkeley any effective donations in terms of the policies of the campus. But there's no doubt that the Students for Justice in Palestine nationally are well organized. I assume they're well funded. Think of all of the tents that were put up at campuses around the country, how similar they were. Somebody was paying for them. And I can give other examples of what they've done. I've never seen an analysis of where the money is coming from for that. A lawsuit was filed in the Southern District of New York maybe 6 weeks ago by a law firm, Greenberg Traurig, that names the Students for Justice in Palestine as a defendant. And I think it's in part trying to figure out where is the money coming from. But I do believe there's a degree of coordination. I do believe there's funding, but so far we don't know where it's coming from.
Is that something that law enforcement ought to be looking into, or are you getting into a pretty tricky area when you're talking about the First Amendment and the other issues you've raised?
You're certainly getting into a tricky area because there's a right to engage in speech. There's a right to financially support speech. But where it becomes complicated is there's no right to materially support terrorist activity. In the United States Supreme Court, not quite 15 years ago, in a case called Humanitarian Law Project versus Holder, said that there's no First Amendment right to give financial support to a terrorist organization. Hamas is a terrorist organization. That's clear under the law. And if it's Hamas, and I'm making this up, that's supporting things, then you're outside the scope of the First Amendment. And that's what the lawsuit in New York is trying to find. I'm making no accusations. I don't know. But that's the relationship between the First Amendment and the ability to stop terrorist organizations.
Dave has a similar kind of question about the protests we've seen. Do you think there were a large number of outside non-students agitating and organizing the student protests? That's been alleged, I know, at UCLA.
I think it'd be difficult to generalize across all of the campuses. And for many of the campuses, the answer is we don't know. It's interesting that they did a study or an assessment at Columbia of those who were arrested when the building was taken over. And we all saw the count. And I think it was about, and I'm just remembering here, about 2/3 were students and 1/3 were non-students. I know at UCLA, the counter protesters, a number of them have been shown to be non-students. But I don't want to imply by this that across the country at protests, it was mostly non-students.
Yeah.
At least at Berkeley, it seems a lot of those who were taking the pro-Palestinian position and those who were taking the counter position were students on campus.
Francine and others as well want to know, how should universities implement this notion of better educating students, and also the notion of being able to tolerate differing points of view and have civil conversations on these difficult topics? You said earlier you didn't think you could have a conversation, a panel of people disagreeing on some of the issues that we've talked about. They're so inflammatory.
Sure. I think we can and must teach how to talk across differences. There are a number of programs that have been created, both nationally and in particular schools, about conversation across difference, and we can teach that skill, and we must. we can educate students about anti-Semitism and Islamophobia and racism. And we can and must do that. We can and must educate students about the Middle East and the history of what's gone on there. The only thing that I said was, at this moment in time, I'm not sure it's constructive to have a panel where those who believe Israel shouldn't exist and those who believe the existence of Israel is essential engage with one another. Both views should be expressed. I'm just not sure right now, at this point in time, that such a discussion would be constructive. I'd love to be proved wrong, but maybe because I'm in the middle of a campus, I worry that those positions right now are so diametrically opposed with nothing between them and so deeply felt, it's a conversation that would be much easier to have after this war is over and after the hostages are released.
Many people, I'm told, have asked this one: is there any limit on hate speech beside disallowing hate speech that encourages violence against the group that's being hated?
The United States Supreme Court has been clear that hate speech is protected by the First Amendment. One of the most frequent questions I get is, where's the line between free speech and hate speech? That's a false distinction. Hate speech is generally protected. Let me give a couple of examples. St. Paul, Minnesota adopted an ordinance that prohibited burning a cross or painting a swastika in a manner likely to anger, alarm, or cause resentment. Those are vile symbols of hate. The Supreme Court unanimously declared that unconstitutional. In the early 1990s, over 360 colleges adopted hate speech codes. Everyone to come to court, without exception, was declared unconstitutional. When can hate speech be punished? If it amounts to incitement of illegal activity, and there's a test for that. If it's a true threat, certainly it can be punished. But the reason for this is, and it's different than in European countries, in the United States, all ideas and views can be expressed, even horrible ones. And hate speech is an idea, even though it's something we should detest.
A couple of people have asked this question in one way or another. Should participation in these protests be considered for people when they're making applications for employment?
I want to separate what's legal versus what's illegal. If somebody is engaged in a lawful protest, then I'm troubled by their being denied employment because of it, because we then punish them for exercising their First Amendment rights. But when students are doing things that are illegal or even violating the rules, that's very different. And I think that that then isn't conduct that's protected by the First Amendment. But what I always say to my students is, we will do all we can to help each of them get a job, but we can't protect them from their advocacy. I tell students in orientation to be careful of what they put on social media. Not that I want to stifle their speech, but that I know of employers who have rescinded job offers because of what they've seen students post on social media. And so we want to help the students, but we can't protect the students from the choices that employers are going to make.
Here's a question from David Abel, a name that many people may recognize. Would teaching at the law school that Israel illegally occupies the West Bank be acceptable? By analogy, would teaching that Trump won the 2020 election be acceptable?
Professors have broad academic freedom to express views. I would hope that our faculty would be much more balanced than that. But the reality is, I think a professor who expressed such views would be in the scope of the First Amendment. But there you get to what I think is the incredibly difficult line. Where does academic freedom end? And we say what the professor is teaching is impermissible. Is teaching that Trump won the 2020 election the same as teaching that the earth is flat or that the Holocaust never happened? Is it so beyond what is reasonable that it should be punished? There's certainly no evidence that Trump won the 2020 election. Every court to consider it found no evidence that there was election fraud that cost Trump the election. So I think there's an argument that a professor who teaches that is teaching something that's so unreasonable, it is like teaching the earth is flat. But I mean, it's hard to know where you draw that line.
Here's one that does not come with a name, but it does make, I think, controversial statements. I don't know if they're true or not. It says the co-founder of Students for Justice in Palestine, who teaches at Berkeley, has stated in his class that the population of Jews in Israel was only 3% in 1948, adding that Jews are not a people. He says a recording of this was presented to Berkeley administrators, and that they did nothing. In his lecturing role, is his speech protected, even if it includes false historical information? Maybe we should take the last part of that question without trying to respond to the specifics. Sure. At the beginning, I have no idea if those things are true or not.
I have no idea either. This goes to the same question. When is a professor in class acting so irresponsibly, so no longer be protected by academic freedom? And we give professors a great deal of latitude, and we know that professors inevitably will express some views. But is expressing false facts that are so extreme, like teaching that the earth is flat or teaching that the Holocaust never happened, or something that's irresponsible? If professors are teaching irresponsibly, then I think it is a basis for saying, you know, if this isn't factually true and you're presenting, if I were to teach a constitutional law class and misstate the cases, I think somebody could come to me and say, you're not teaching responsibly. You have the obligation to teach the law. And if somebody's teaching history, if it's beyond interpretation, if it's clearly wrong, then I think it's a basis for saying no longer is it protected by academic freedom.
I would think you'd have to have very specific evidence, though,
Right.
that was the case. It would be pretty easy to argue one way or the other.
I agree.
Yeah. David wants to know, can a university require students to take a class on the conflict? Presumably he means the conflict between Israel and its surrounding neighbors.
The simple answer is schools can require that students take whatever classes the schools want, with only the most limited exceptions to that. So if a school wants to require, say, a college take foreign language, it can. If it wants to require science and math classes, if it wants to require history classes, schools, and this is true even more so at the high school and middle school level, they get to decide the curriculum. And there's very little limit on the ability of schools to prescribe what courses that students have to take.
Lois has a question that others may as well. She says, my granddaughter attends Berkeley. I don't know if it's UC Berkeley. She didn't say the law school. How do I know she's safe? What is the university doing to keep students safe? I guess I would follow that by asking, do you think they're in danger?
No, I don't think they're in danger at all. There have been virtually no incidents on the Berkeley campus of any violence or assault directed at any Jewish students or other students. So, I mean, in terms of safety, there's no reason to believe that students are unsafe because of this issue. Now, Berkeley is a city, and there is crime in a city. So obviously somebody should be careful about being out at night and things like that. But this issue doesn't cause, I've not seen anything that causes students, rare exceptions. There was an incident in December where a student got hit by a bottle, but we're talking about very rare instances. It's not about physical safety on campus. And the campus does take physical safety enormously seriously. The UC Police Department is very much present, especially present at places where there's encampments around, to make sure that everybody is safe. So in that sense, based on everything that I've observed, and I'm at the Berkeley, I walked across campus today to go to a meeting, I haven't seen anything that causes me to believe that students are physical in danger. On the other hand, within the law school, we've taken a lot of additional security precautions as a result of wanting to make sure that our students are safe.
Back to the very beginning of this program, did you feel unsafe after the incident that occurred in your own home when people came there and demonstrated as they did?
I didn't feel physically unsafe. The only qualification of that is, for about a week afterwards, my wife and I received a large number of death threats. I didn't take them particularly seriously. None seemed serious enough to take. On the other hand, I've gotten death threats over the years when I've taken public positions. I think for my wife, it was so unsettling because it was the first time she'd ever been subjected to that. Our office at the law school got a number of calls that they were coming after us. So the event in my backyard didn't make me feel unsafe, just tremendously upset and distressed. But we did receive a significant number of death threats for a number of days afterwards.
I'm sure that this is not the way that you chose to become a well-known public figure. You already were a well-known public figure. Now you're known for reasons that you probably don't want to be, but you have been extraordinarily forthcoming about your own experience and very helpful, I think, in talking about the issues that arise and that are going to continue to arise on campuses and elsewhere because of anti-Semitism. Thank you so very, very much for being with us, Dean Erwin Chemerinsky. It's great to have you.
Thank you. It's always so wonderful to get the chance to talk with you. Thank you for doing this, and thanks for inviting me to be part of it.
Okay, thanks everybody, and have a good week. We'll be back next week.